I'm an independent commissioner and chairing the steering. Alongside me on my left is Stephen McNally, who was a councillor but also was an independent commissioner as well for the steering. And on my right, I've got Alan Watson, who's an independent steering commissioner. The topics we're dealing with today are renewable energy, infrastructure, transport and designations. The staff here, who will introduce themselves in a moment, are here just to outline the Section 42A reports, consider the evidence that's presented today and any submissions, and to give a right of reply once the hearing is adjourned. We have been delegated and appointed to consider submissions and further submissions to these 4 topics and make a recommendation to council in due course. At this stage, the hearings are scheduled through to September this year. Section 42A reports have been circulated and taken as read. We have read all sorts of submissions, further submissions and evidence that has been circulated, and also any legal submissions that have been circulated. The Section 42A reports are simply a recommendation from the staff to us based on what they've considered so far. And their recommendations may change. We may decide to change their recommendation to us in due course. Basically outlined today, the officers will outline each of the reports, the Section 42 report, and then we will hear from the submitters. Some attending in person and the others are virtually appearing online. We are the only one that can ask any questions. However, sometimes there are points of clarification. We may get the staff to ask something that they need clarity about, better understand what I'm saying, that's in their evidence. In regards to housekeeping matters, for those people who are here, the toilets are at the back of the building, so yeah, you go to the front door, turn right and right again. And you go out the emergency exit on my left, and it's down left and then left again. And in the event of an emergency, follow the staff outside and we'll assemble in the front car park. Right, what I'll do now, we'll get each of the staff to introduce themselves. So I'll start with AK on my left.
Morena, I'm AK, the Hearings Administrator in the District Planning Team.
Start on my right with James.
Morena Koto, Koto Takulunga, District Planning Team Leader.
Morena, Courtney Worcester, Manager.
Morena, I'm Lynette Morgan. I am the Policy Planner and I am the 42, a report writer for designations.
Koto, I'm Keita Baxter and I'm the Section 42 writer for renewable energy.
Morena Koto, my name's Jerome Wyeth. I'm the reporting officer for the infrastructure chapter. Maybe go to you, Melissa.
Kia ora everyone, my name is Melissa Pearson and I'm the Section 42A officer for transport.
Thank you very much. And I think also we got online and we got Tim Williams, have we?
Kia ora koutou. Yeah, I'm just watching for now. Thank you.
That's it.
And,
Yeah,
I'm submitting on behalf of Forest and Bird.
thank you very much. Thank you.
Thank you.
Anyone else online who's just listening at the moment?
Morena, I'm Matt Collins, Associate Transport Planner. I'm assisting Ms Pearson with the transport topic.
Okay, thank you very much. Before we get the staff to go and outline the Section 42 reports, anybody got any comments about the process for the hearing? And we'll continue on with the staff. No comments, all right? So who's going to go first? Renewable energy, is it first?
Yep.
Okay.
So yeah, renewable energy, there was 16 original submitters with 93 submission points and 168 further submitters, like 722 submission points. Submissions came from a range of different people, from government agencies, infrastructure providers, iwi groups, community interest groups, the primary production sector and others. These submissions covered a range of matters. The the key matters for consideration, so clear definitions for terms relating to renewable electricity generation, implementation of national and regional policy direction for renewable energy generation activities, avoidance of reverse sensitivity effects on existing or consented renewable energy activities, and enabling some renewable electricity generation activities in all zones rather than limiting to specific zones. Consistent treatment of wind and solar electricity generation, and some minor wording amendments to improve clarity of provisions. Then it also should be noted that in my renewable energy approach, I've tried to make it consistent with the infrastructure approach that Mr. Wyatt will go over as well. So yes, that topic.
Can I just ask one question? Paragraph 303. It's a very simple question. Monitoring masts. What's a monitoring mast?
I think that's like a mast they put up to I guess monitor like wind speeds and sort of thing.
That's my understanding.
Okay, you might want to do the right reply, because I'd like to know, because it says 80 metres, and I just
Yeah.
want to know what the chances of how many appear and what they're used for. You don't mind?
Through the chair, just advise, I've been recently working with an infrastructure provider that is using monitoring for wind up into Cal. They're looking at doing that, so it would be those. Well, do the right reply.
Yeah, just very briefly, I just want to know.
Situation that is going to involve.
Okay, thank you very much.
No, just they could be there for 5 years. So fairly relevant.
Any? No, thank you very much.
Thank you.
Okay, so I'm going to give an overview of the key recommendations in the infrastructure chapter. I've got a few more slides in Kenton, but in the interest of Mr. Watson's comments, I'll try to keep it relatively concise. And yeah, happy to take questions that go right here. So in total, there was 333 original submissions and 1,129 further submissions on the infrastructure chapter, so quite a lot. The main submitters, as you'd expect, is infrastructure providers, and you'll hear from a number of those throughout the course of this hearing, including Transpower, Top Energy, telco companies, and KiwiRail. Other key submitters include central and local government authorities, environmental organisations, including Forest and Bird on the call now, and primary sector submitters. Just a quick summary of some pre-hearing discussions that took place on the infrastructure chapter. So this followed on from hearings 4 in terms of the relationship with the infrastructure chapter and how it interacts with other key part 2 chapters, including coastal environment and indigenous biodiversity. So the purpose of these discussions was really to narrow the issues down and assist with a more streamlined hearing process for this hearing. Took place in the end of last year, attended by a number of infrastructure providers. Other submitters were invited but didn't have the capacity to attend at that time. And in general, it was collaborative and constructive discussions, and we made some good progress on a number of key issues, including the relationship with other chapters and some amendments to specific provisions of interest. So a summary has been provided to you and published on the website along with some working draft provisions and meeting minutes. In terms of some of the key recommendations, I've recommended some amendments to the overview section and the advice notes to really clarify that the other sort of more directive effects management policies and other part 2 chapters apply to infrastructure activities, really just to make that clear to all parties. Also recommended a new advice note to make it clear that the rules relating to buildings and structures in the zone chapters don't apply to infrastructure activities, as that would effectively negate the purpose of this chapter. Some amendments to deleting and amending effects management policies that I felt directly sort of conflicted or duplicated with other effects management policies in other chapters. And also a new national grid policy to give effect to the NPSCT, which was heavily informed by discussions with Transpower. Next. So these recommendations here, I might not dwell on all of them. They're more sort of technical changes to the policies and rules, and really the intent here is to sort of get rid of unnecessary requirements that enable sort of essential infrastructure to occur. So some of the key changes to the rules was Rule 7, which was a new rule relating to overhead electricity lines and telecommunication poles. So quite a few recommended amendments to that rule so that it applies in all zones, whereas the notified version only applied in sort of rural zones, different height limits that apply based on the sensitivity of the different zones. And also a new condition which would enable co-location of telecommunication facilities in certain zones. And for a number of these rules, I've also recommended a RDA status when compliance is not achieved, which I think is more effective and efficient. But that's excluding those standards relating to electromagnetic fields and radio frequency fields, which I think non-compliant is appropriate. So critical electricity lines, this is a new feature of the PDP, I guess you could call it. And the intent is really to sort of give effectiveness and direction in the RTS and to better protect important distribution lines in the district, recognising that, it is vulnerable to a lot of extreme weather events, as we all know. And the introduction of these critical electricity lines into the PDP was followed on from discussions with Top Energy prior to the notification of the PDP. And it's really aligned with what's in the Bombay District Plan. So we thought some consistency there makes a lot of sense. And really it's about reinforcing compliance with national regulations under the Electricity Act. It's not about sort of introducing more onerous requirements, as you might hear. Unfortunately, due to a GIS error, the intent was that the 110 kV lines and the 33 kV lines were included as part of critical electricity lines in the PDP, but the 33 kV lines were omitted. Once council saw that omission, wrote letters to all affected landowners advising them of the Top Energy submission requesting the 33 kV lines were introduced into the PDP to really enable them to understand that and make an informed further submission. 5 further submitters were received on that submission point, and you'll hear from many of those submitters on Wednesday, generally raising concerns about the impacts on private property rights. So in terms of my recommended amendments, I've recommended retaining rules and really just to refine them to focus on that compliance with NZDCP 34 and the tree regulations. And it's really about improving the compliance and visibility of those regulations. It's often district plans much more visible to everyday people. Expanding it to cover 33 kV lines, and this was really the intent when the PDP was notified, and also some new definitions for critical electricity lines overlaid to clarify exactly what's been captured here.
Just before you move on from them, for those people who are present at the moment, the panel did request a copy of the letter that was sent out to those people advising about the omission, and that letter was dated the 7th of August, and that's been taken for us. And the other thing we asked for was what in the Bombay District Plan regarding critical electricity lines, and that's been provided to us as well. So we will probably have questions for those submitters dealing with that and the infrastructure officer in due course. Thank you.
Can I just raise a question on that, Jerome? Just in terms of the recommended amendments that you made, apart from the 33 kV lines and the CEL, are the other matters consistent with what was sorted out as part of the mediation or part of the concern?
Yes, yeah. Essentially, it was just refining those requirements to comply with those. Yeah, there's a couple of outstanding matters that Top Energy has around some of the conditions, but yes. During those discussions, we talked about the lines, and Top Energy was largely supportive of the recommendations.
Thanks.
Lastly, in terms of some of the outstanding issues and evidence and hearing statements that have been pre-circulated, in general, I do note that many of the recommended amendments are broadly supported, and you'll hear from another submitters about that, and that's in particular from those involved in those pre-hearing discussions. However, there are some outstanding issues. That includes further requirements to the rules relating to overhead electricity lines and telecommunication poles to separate those out with different rules. Top Energy is seeking a range of further amendments, including new objectives, policies and rules for infrastructure in the road reserve and a 25-metre height towers, which was not discussed during pre-hearing meetings. Forest and Bird, who you'll hear from shortly, had a number of concerns about the new policy direction relating to operational and functional need, and that there's no direction to avoid, remedy or mitigate adverse effects. From my perspective, that's just a bit of a misinterpretation of how those amendments are intended to work in practice, but we can advise on that in due course. Ahipara landowners and others, there's a group of submitters that have concerns with the critical electricity lines, ranging a range of concerns including clarification of the setbacks, the need to repeat national regulations in the plan, and also for the subdivision rule to be a controlled activity rather than discretionary. And lastly, farming holdings exemption from the critical electricity line for the NAPA special purpose zone. Happy to take questions or pass on to Lynette.
Yes, just looking at the list that you've got there, the top energy submission or the evidence that you've got from them. They participated in the high court mediation, the expert conference and whatever you refer to as.
Yeah.
They've come in with pretty comprehensive evidence, seeking a whole range of changes. Are those mainly minor? Would you see them as minor changes to what you're doing? Do they question the intent of where you're recommending we go?
Yeah, I think they're mainly minor sort of amendments where probably Top Energy is probably willing to push the boat out a bit more than I was willing to sort of recommend. For example, the 25 metre height tower, that's very uncommon from my experience in terms of district land provisions. Yeah, so I think that's just an area. I think some of that was informed by some more recent advice I've had from internal people within Top Energy around operational and functional requirements. So it's good to hear from them on that.
Thanks.
Thank you. Mr. Pearson, now?
I just answered.
Oh, yeah, sorry. Yes.
There's a couple of things in your executive summary, and I'll just touch on it. You note there under 2B, concern the effects management policies were not appropriately give effect to higher order direction. And in particular, your paragraph 18, you refer to the NPO's HPL. So if you think of the objections from the Oromari landowners group, you're part of that is we've got a dam, Maui, that's being developed there. And that infrastructure will provide irrigation for all those areas through one in North Onahari, Backerack, etc. So do you think that that's one of the questions that's being raised in there, not giving appropriate consideration to the higher order?
That statement there was really about there was two policies, P2 and P3 in the notified infrastructure chapter, which talked about managing adverse effects on coastal values, on natural environmental values, on historic heritage values, a whole range of values that didn't quite align with what's in other chapters. And that's sort of the key issue that we worked through. Didn't so much get into NPS HPL. It has been something that's been too front and centre in those discussions. So that statement there was really about more those natural environment values and that sort of interaction.
Okay, so the next one was 3C, clearer policy direction to recognise and provide for the operational need, functional need and technical requirements of infrastructure. So it comes back again to we're putting infrastructure in place to provide for those hydrographic lands. For instance,
yeah.
Another example would be overland flow paths, which we'll get to later on.
Yeah.
So it pops up right through all of your document. Yeah. Those two, which you've highlighted in your executive summary.
Yeah. Yeah, I guess from my perspective, recognising the operational need of infrastructure in particular environments is a really important sort of direction for the infrastructure chapter to provide. It aligns with the national planning standards, which have those concepts of operational need and functional need defined. So I was really just trying to consolidate that direction, make it clear for all infrastructure activities in all environments that can then be considered alongside other provisions of PDT.
Yeah, and I'll leave the other one related to the critical electricity lines. Cool, we can say. We did from the submitters. Thank you.
We're going to have a change now. We're going to go to you now.
I think
It's like transport next. I don't mind how it goes.
These are notions.
So as well as an overview, part of my presentation is to advise the changes that have been made since my report was filed. Just to give you a bit of an overview, there are 19 requiring authorities in the PDP with existing designations. 41 of them are rolled over without any modifications, and there were 145 rollovers with modifications, and there were 3 with new designations. Sorry, I'm not So a summary of the designations you'll find in my report on page 6. And it outlines the total number, those that rolled over and the new ones. And I haven't repeated it here because you can just see it in the table. But more importantly, since my report, you will see that the Ministry of Corrections designation, they made 2 submissions and there was a need for a minor amendment, and AK has just given you that. And so the new amendment is shown in red. So a discussion took place between Mr. Grace and I, and there's now been a correction to both the title, and in red you'll see that we've made some amendments. They're minor amendments, and they're really around some little bits that were missed out, and I'm recommending that those be accepted. They've been agreed between Corrections and I. Radio New Zealand designation RNZ 142, they made 2 submissions. They also sought a new designation. And when the report was released, I was contacted by Mr. Pedler, who said to me, we aren't actually seeking a new designation, we're actually seeking to roll over our 2. So they've also filed legal submissions that confirms this, and they're just basically seeking a rollover of the 2 designations with minor amendments. And I would ask that that be recognised and accepted, and that they're not seeking a new one.
You covered that well in your report.
Chorus, they've now had a name change, and they seek that the name change Spark New Zealand Trading Limited be noticed. So I have amended that, and I ask that that be accepted by the panel. This is not a modification, it's just a name change. And I haven't provided you with the new designation. I've provided that as new designation. I ask that you accept that. For the reason that it's basically just a name change. It's not a modification. Top Energy. Top Energy, there were 2 submissions, one from Spark and one from Top Energy. Top Energy sought to roll over these 17 designations with minor amendments. They are seeking some further corrections, which are set out in Mr. Adams' planning evidence. Some of the requests I agree can be made, or I recommend are made. And one is to change the site identifier in TE 208, and I recommend that is made. I agree deleting the condition 2 from TE 243, and I recommend that is made. However, there are some that I do not recommend are made, and I've set those out. Yeah. Mr. Badham has said.
You've gone past that.
Oh,
Over me, okay.
you can look at that. Yes.
Oh,
In his planning evidence at 8.1.
It's not right.
that one.
Yes, thank you.
Thank you.
He refers to TE 245. I'm actually wondering whether, and he will be able to talk to this, I'm wondering if the reference is actually TE 244. Because that is the reference that he makes. And the numbering to TE 249, again, I'm wondering if the reference is TE 247. The issue here is that he's asking that the numbers be renumbered. Now, I'm not going to go into too much detail because he can address this, but the issue with, if it is TE 244, there were 16 conditions that applied to TE 244. Numbers 13 and 14 were in the original designation as it was made on 22nd of August 2011. If all the numbers were removed and then renumbered, it would actually cause confusion. And so my recommendation to the panel is the numbering remains with the original numbers. If the reference the next one he's referring to is TE 247 or 249, as he says, my position is the same. I'm not trying to be difficult, but what I recommend to the panel is the numbering stays the same as the original designations as they were made. So, for example, in TE 244, which was made on the 22nd of August 2011, the numbers stay as they were made in that original designation. But I will leave that to Mr. Bannon to talk to the panel, and I'm quite happy to answer any questions arising either subsequently or in the right reply. The next one that we have is, you can tell it, is designation F, as a council designation F9, FN 160. Now, I thought it would be easier when this one came up for discussion, because it's going to be addressed on Wednesday, if someone from infrastructure came and was available for the panel. FNDC saw a rollover of this particular designation with no modifications. However, one submission was received from Luckmore Farms Limited, who seek FNDC plan and provide for plant expansion. There's no current plan to upgrade this wastewater treatment plant. And my position in respect of this for the panel is that the designation is rolled over without any conditions. However, I accept that as a matter for the panel.
Where does the comment, there's no current plan to upgrade the wastewater come from? If someone made that comment?
Infrastructure. Upon my report being released, I sought some advice from infrastructure, and they advised me that. And someone from infrastructure will come and be able to confirm that for me.
I think there's a look clause not referred to that in some of the evidence.
Yes, they do.
In a long-term plan for
Yes, they do.
upgrading, I think. I'm not sure who it is.
One of the ecologists in the evidence filed also indicates that as well.
Will we receive any advice perhaps of a legal nature about the extent that we can make recommendations beyond what we apparently can? You know, are we in a position to agree with submitters that we can add conditions to the existing designation, for example?
In the right of reply, I think council position will be that we would provide some legal advice. Is that correct, James?
Yeah, thank you, Mr. Chair. We have provided the materials, particularly the legal sites, to our representative. We have advised him that we will furnish him with any further evidence, because at the stage it wasn't particularly clear what at the time was what specific matters were going to be applied as conditions, for example. We've taken the position of we'll wait and hear from the submitter, I guess, to see whether there is any in scope specified conditions to consider. I would suggest that there is no ability for a submitter to request expansion of a designation that is strictly the realm of the requiring authority. But we can provide comment on that as well. And I think there's probably a little bit of confusion around the long-term plan and infrastructure generally in terms of what essentially the industry has been through in the past 3 to 5 years in terms of responsibilities and changes. But my understanding is the same as is that And the last 3-year long-term plan, which is current plan for the next 3 years, which funding has been set aside, there isn't any stage provided for, but we can provide a more explicit statement to you as part of that work report. Yes. Thanks.
I think I've read that one of the conditions we wanted was something to do with order, 100 metres or something along those lines, but there's a condition on the consent that refers to order, the regional council submission. And decision, I think,
There is a
condition 14 refers to order. So anyway, we'll deal with that when we get the evidence, then we can get right to reply. Is that it?
That's my question.
Yeah. Probably because I'm not a plan, but anyway, I'm going to ask them anyway. The impact on paragraph 30 or 2622, national policy statement, announce future changes. I see we just, because if you look at your table there, under paragraph 30, it refers to national policy statement, indigenous biodiversity, to stop cease implementation of, and that refers specifically to significant natural. Urban development, looking at an upland for 30 years of heavily growth, and national renewable energy allow production to be doubled. How do we deal with that in these summaries? I realise I've heard it before, it's not law yet, but.
Yeah, look, Mr. Chair, I think it's less than law, about conceptual at this stage, so there's not even language or words to be considered. And I think the question of implementation and costs, council has spent many years and significant money to bring a very outdated district plan forward. This process will, in my experience, generally be allowed to complete so we can implement some of those improvements that we've worked through this aid process and system, I think. And the other thing is, obviously, there's been a lot of public support and input into this process as well, time, money spent. We have had a recent experience that a change of government also is a back to the future experience, and that we're still dealing with the RMA. The timeframes are likely to be very similar, likely to be in terms of if legislation is passed, likely to be towards an election. But my view is that I think completing a process that has been started and invested in better meets our current requirements under the law. Having some discussion around the traps, particularly earlier today, my understanding that a lot of the national direction will be the same, if not similar. So some of the things that we'll be looking to achieve will be the same. Just maybe different ways of doing it.
So with all due respect to my fellow commissioners, it's probably my council hat on looking at costs going forward and the impact on ratepayers. The next, I did send ask some questions relating to 65I, the Kotoa Water Conservation Reserve. Be a similar thing. It's currently designated, even though that Carroll Creek Dam and those sources have been designated.
Through the chair, I think what might help is designations are a lodgement process, and I think that's requiring authority comes to us, so we can't make them do anything. That's the difficulty, I think, that in this process, because it's a lodgement process, it's almost a bit backward. And so
The requirement authority will have to request that we revert up.
Come to us.
Yeah, so it's staging process.
Yeah.
Yeah, yes, but similarly, it is a notice to.
You can see also look at the finance cost.
I understand.
The next one is 92 and 93. We talk about farmer foldings. They didn't actually no submission to the city, but you refer under 93, 1 to 6, that relates to airport operations, and with 6 being specific to Vaillan's airport. Does that particular designation also apply to Kotoa Airport?
The designation is set out there, and the designation only applies to what is set out there.
Yeah, okay. The next one I did send earlier was 171 lapse designation. Education, work in the road.
Again, it's very much as we indicated, because it's a lodgement process,
Yeah.
we can't make the ministry keep a designation.
I think Commissioner McNally's question was more, where is it? And who owns the land? The Ministry of Education still own the land, and but they want the designation to lapse. Because I did the designation, and I know where the site is.
Right.
But I think somebody can tell us either the Ministry of Education still own it.
Yes, they do, Mr. Chair. 334 Waipa Road. This came up as part of discussions around
What number was it?
334.
334.
I confirmed that with the growth team. It came up as part of discussions for the spatial plan. My understanding, well, not my understanding, they still own land. That's the site.
Yeah, blending schools, which comes up under infrastructure. Well, that's what I said. And the last one, 198, Kaya Bridge, yet to be constructed.
So that might be, it's not necessarily just for the works through the chair. Again, like it might enable works, but they will still potentially need the physical area designated to be part of that network.
Roading.
Yep.
Okay.
Yeah, still roading, good, nice.
Okay, thank you.
Okay.
Thank you.
Yes.
Thank you.
Sorry, was that a go ahead for me?
Yes, Ms. Pearson, yeah.
Thank you. So for the transport, again, I've got quite a few slides, but I will whip through them as efficiently as I can. You've already been introduced, Mr. Collins, so quite a few of the recommendations on the transport chapter are very technical in nature, and I've relied on Mr. Collins' expertise for a lot of the recommendations. So Mr. Collins is here online today if you have any initial questions, but equally he will be at the hearing in person tomorrow, which is when all of the submitters that want to speak on the transport chapter are to be heard. So he's able to respond in person to any panel questions then. So on the transport chapter, there were 326 original submission points and 632 further submission points. Again, like the other topics, quite a broad range of sectors. You've got your actual transport infrastructure providers, NZTA, Kiwi Rail, so larger organisations right down to smaller businesses and individuals. If we go to the next slide, please. So I'm just going to take you, these are sort of what I think, oh, there we go, back to that one. Oh, missed it again. So these are what I consider the 5 key major changes to the transport chapter. Some of them are quite significant, so I'm just going to talk you through some of those. Some of these significant changes have not attracted much evidence, if at all. So some of this is more just for panel information as opposed to responding directly to evidence. The first one, decoupling of the engineering standards. We've got removal of car parking minimums, the introduction of a new transport network hierarchy map, rules for newer altered vehicle crossings, Tran R2 and Tran R9, and that is the combination of those two rules has probably attracted most of the evidence that you're going to hear tomorrow. And then new rules and standards to better manage railway level crossings. So if we move to the next slide. So the decoupling of the engineering standards, this is really a continuation of what you, if any of you are on the panel for hearing 8, this is a continuation of that where it was recommended that the PDP is decoupled from the engineering standards. So I've worked with Mr. Collins and we've also run these changes past the internal transport engineers at the council to try and figure out how we actually do this decoupling process and decide what elements of the engineering standards actually need to come through into PDP rules in the Tran chapter and what is really more technical information that can just stay in the engineering standards. And the lens that I put over it was really whether or not the technical standard or rule was needed to manage a potential adverse environmental effect like public safety. And then if so, then that should come through as to a Tran chapter rule. So you've got a range of amendments to the transport chapter to do that, which is set out in key issue 1 of my section 42A report. Happy to talk further to those if needed. The other key issue which we will hear evidence on tomorrow is about referring to a specific version of the engineering standards, which I think again has been canvassed before as problematic. So that has been largely resolved. All of the references to the April 2022 version of the engineering standards have been recommended to be deleted from the transport chapter. There is only one note. It's an explanatory non-statutory note, and it refers to the most recently adopted engineering standards as a signpost really to plane users. So if we go to the next slide. So the only outstanding issues about that decoupling process that were raised in evidence were raised by Foodstuffs. Concern that referring generically to, the most recent version of the engineering standards was ultra vires, and that the use of the word will in note 2 seemed to indicate that all proposals would need approval, engineering approval, when in some cases they won't if they complied with everything. So again, we'll hear evidence on that from Mr. Badham on behalf of Foodstuffs tomorrow. I think the use of the word will could probably be changed to may, because I agree that in not all cases an engineering approval would be required. But I don't think we have an issue of vires with respect to the note, because it is in a non-statutory section of the transport chapter. Right, next issue is car parking, which is quite a major change, but hasn't attracted any evidence on car parking. But the submissions, there were quite a number of submissions signalling that all of the references to car parking minimums should be removed from the TRAN chapter, and that is to align with the direction in the National Policy Statement for Urban Development, which is once a council has reached the threshold of being a Tier 3 council, which means it contains an area that is classified as an urban environment, then it is required under the NPSUD to remove objectives, policies, rules, or assessment criteria that have the effect of requiring a minimum number of parking spaces to be provided. So I've made my recommendations based on what is likely to come with respect to the spatial plan for Kitakiti and Waipapa. If that is adopted, then the council will hit that Tier 3 status. So my recommendations have been made accordingly. If that process doesn't happen, then I will have to address that later on in the hearing process and amend my position if that doesn't eventuate. However, there is definitely still a role for the transport chapter to play in terms of ensuring that car parks, if a developer or landowner decides to provide them, that they're correctly formed, sized and located to make sure that they're functional. There is nothing in the NPSUD that prevents a district plan from controlling accessible parking spaces, loading spaces, controls on stacked parking, bicycle spaces, end of trip facilities, or parking and manoeuvring dimensions. So those elements of the TRAN chapter I have recommended retaining. Then the only other major change related to parking is a sort of unintended consequence. Mr. Collins can speak to this potentially more if you would like more detail, but a new rule managing pedestrian access to allotments where vehicle access is not provided. And this is sort of a perverse outcome that has been observed in other districts, where when you take away those minimum car parking requirements, you often see developers going, well, in that case, if I don't have to provide vehicle access to a site because there are no car parks, which usually isn't too much of an issue if it's a site where all the buildings have direct access to the street. But in the case of rear sites or developments sort of down along access, if the only access you have is a small pedestrian path, that raises a lot of issues in terms of emergency access, maintenance, and even just practical day-to-day things like trying to get your bins out. So that's the purpose of new rule TRAN RW. I can take a pause here for any questions if needed, or I'll just keep cracking on.
Going on, we'll ask any questions when you finish, just in case you cover what.
Sorry, I didn't quite catch that.
Just carry on and we'll ask the questions when you finish, in case you cover what we're going to ask you.
Sure. Right, next one is the introduction of a new layer in the PDP labelled the Transport Network Hierarchy Map. At the moment, that's just uploaded to a viewer. The link's there, but it's also included in the Section 42A report. But the intent is that the information in that viewer would be incorporated into a PDP layer at the time of decisions if that was accepted. That really came from submissions saying that Tran Table 10 and the descriptions of the various classifications of road really weren't clear enough for an average plan user to understand. Is my road a collector road? Is it an arterial road? Is it a local road? So spatially mapping those enables a lot of the transport rules that rely on those classifications to actually be interpreted easily. I can go into some more detail about where those classifications came from, but really they are based on the one network road classifications, I guess, and that is what district council staff would be using in-house to interpret Tran Table 10 anyway. So nothing's changed in terms of through the mapping process. It hasn't elevated the status of a road or given it a lower classification. All it's done is spatially translate what was notified. Right.
Fairly simple. So what's the difference between referring to that, and that's okay, and not referring to the engineering standard, because some people don't want that. But it's an outside document, isn't it?
So that was one of the reasons why we've called it a transport network hierarchy map. We've used the ONRC classifications as a base, but it is a standalone map as opposed to cross-referencing to an ONRC map. And we did consider whether it could just be a cross-reference to that, because there is ONRC mapping as a non-statutory layer, but then we hit the same issues that we would with the engineering standards. So if that is, I guess, one of the limitations of the transport network hierarchy map is that it is static, in that once it's notified, that is the map. And if you needed to add in new roads that were vested since the decisions version of the PDP, then a plan change would be required to add those in. But yeah. Yeah, and there was no evidence received on introducing this map layer. If we move on to newer altered vehicle crossings, Tran R2 and Tran R9, these rules work as a pair. So Tran R2 manages your vehicle crossings onto any other road that isn't a state highway or a limited access road, and then Tran R9 controls vehicle crossings onto state highways or limited access roads. You'll hear quite a lot of evidence on this tomorrow, but my intention I completely agree with submitters that the relationship between those two rules wasn't clear. And there is, I think it was picked up by the foodstuffs evidence, potentially Mr. Badham, that there is one erroneous reference to state highways still in Tran R2. So that was unintended, that was still in there. So I would be recommending that was deleted so that the two rules are completely separate in terms of their scope. Made a couple of other amendments, a clear threshold for when a private access way needs to be upgraded to a public road. That's based on the number of allotments served rather than equivalent vehicle movements. This is much easier for plan users to determine compliance, and it aligns with the equivalent threshold in the subdivision chapter. So we're getting cross-chapter alignment as well as making it a lot easier for plan users and the council to interpret and check compliance. And then we'll also hear from Fire and Emergency New Zealand about a number of issues with these two provisions, but particularly the reference to the firefighting water supply code of practice, which both myself and Mr. Wyeth have recommended be removed as part of our wider direction that we've received from the panel in previous hearings, that the PDP doesn't refer to third-party documents or codes of practice as part of permitted activity standards. So next slide. So these are the outstanding issues and evidence with Train R2 and Train R9. I've mentioned a couple of them before. No opposition in evidence to the revised threshold for private access ways versus public roads. There are still outstanding jurisdictional overlap concerns between NZTA and council functions raised by Waipapa Pine, who are not appearing at this hearing, but they have tabled a statement, which is an opposite position to NZTA, who supports the approach that I've recommended, but they are also not appearing at this hearing. I have already covered bullet point 2. There is a range of opinions about Train R9 and its activity status in terms of crossings onto state highways and limited access road, whether that should be a controlled activity, a restricted discretionary activity, and whether there should be a requirement to comply with Train S2, which is the standard that controls vehicle crossing design. So we will cover that off tomorrow. Next slide, please. This is a really quick and easy one. Kiwi Rail have been supportive in the evidence of the amendments that I've made relating to railway level crossings. They've only got one outstanding area of contention, which I've covered on the next slide, about Train SX. If we can go to the next one, please, okay. About whether or not Train SX should apply to all rail level crossings, irrespective of whether they have barrier arms or not. And I have discussed this with Mr. Collins already, and he has recommended that it could, that the reasons brought up by Kiwi Rail as to why it should apply to all crossings regardless are valid. And so we're likely to recommend that explanatory note is deleted, and that would resolve all of the outstanding issues for Kiwi Rail with respect to the transport chapter. And then last matter is trip generation. Again, quite limited evidence on trip generation. You'll hear from a couple of supermarkets tomorrow about the threshold for supermarkets. McDonald's has also prepared evidence in relation to particularly drive-through restaurants, but again, they have tabled a statement and they're not appearing at the hearing. So if there's any questions on trip generation specifically, they should probably be directed to Mr. Collins, as I have relied on his advice in terms of setting those rates and the rationale for setting those rates. Actually, sorry, finally, there is one more. Last slide, promise. This relates to the requirement for integrated transport assessments in the hospital zone. We'll hear from Te Whatu Ora Health New Zealand tomorrow morning. They're concerned that the requirement set out in Tran P7 requires, if there is an infringement of the thresholds in Tran Table 11, trip generation, that they'd be required to prepare an ITA, and they've got a range of reasons why they don't consider that that's appropriate for their particular activity. And that is all from me.
Just compare the evidence.
We've got to hear the evidence, but if you go to paragraph 84, 85, 86, which goes on about the NPSG urban development, if Kerry White Path is not classed as urban development, come tier 3, I'm more inclined to think, well, why don't you what you're dealing with now is the fact it's not tier 3. So should your recommendation not be to us what the planning regime should be, and then when it changes, obviously the council then has to alter the district plan legally?
Do you want me to answer that?
No, sorry, it's just the chair in particular cuts out a little bit.
You're recommending that now, even though the Farnborough District Council is not tier 3, that you're going to wipe out all the parking restrictions. That's right, in simple terms. You're suggesting that if it doesn't get changed, that you review that later on. My question is, why don't you deal with what the law is, that legislation we're dealing with now is it is allowed parking, and you should be recommending us what those parking restrictions are. And then later on, if the NPS comes in, the council will change the district plan, but it has to.
I could completely appreciate that. And that was a timing issue that we grappled with a lot over the last 6 months to figure out what the Section 42A report would say. Ultimately, when we were getting to the point of finalising the Section 42A drafting, it was becoming more likely than not that that Tier 3 threshold would be reached within a month of today's date. So rather than provide you with a position that would be obsolete within a month, I, on the balance of probabilities, chose to provide a recommendation that is likely to reflect the scenario that you will be in when you are making your decisions on the PDP. It absolutely could have gone either way, but in the interest of being the most helpful to the panel as I could be, that's why I've come down on this side of it.
Mr. Chair, just
Thank you.
Ms. Pearson, is the advice that we gave Ms. Pearson was that would be the case, and I think my view as well is that I think it is more transparent to put it up front and get to November or whenever and withdraw that from the recommendations. And I think given that there's a hearing on it, these are the clear and tangible implications of a decision that's booked in to have hearings shortly and a decision in a very short space of time. So I think it was probably better transparency perspective to have that potential consequence outlined. Now, again, we don't necessarily want to have to change our view.
No, I'm not saying so. I'm just asking him. She has explained very well why. And if it's going to change within a month, I can totally understand. However, it might need to be spelled out either in our decision, depending which way we go, why it's being taken out. Because when it happens in the towns, it's going to be the council who's electoral and baby, not the government. Why? Because I can drive around the border, developments in Auckland is a disaster, and with all due respect. And there's cables across the road to charge electric cars. And yeah, anyway, so you've got to deal with the legislation, I understand that, and I understand why you've gone the way you have. Yeah.
No, not on that one. I think we covered it pretty well. Well, what did you come down on the end? I was just looking through in terms of the issue about a threshold for an ITA, an integrated transport assessment in the hospital side. What was your recommendation on that?
The recommendation on that, after discussing it with Mr. Collins, is that hospitals and healthcare services still have an impact on the transport network. Admittedly, maybe they have different drivers in terms of what drives people to visit those types of activities. But to completely exempt them from ever needing an ITA misses the opportunity to understand what impacts there are on the transport network. Again, we will hear from Te Whatu Ora tomorrow about that balance in terms of who pays for an ITA and what that costs, and then the implications of that in terms of taking away from healthcare funding. But when it came down to just transport effects and potential implications on the network, the potential for vehicles still impacts the network. And it may be that a health facility isn't able to control, we're not saying we suddenly want the hospital to provide less beds or provide less services. But the council still needs to understand what the implications of a hospital upgrade are, and that might inform the need for council to actually upgrade roads. So that's where we're sitting at this point in time, but haven't formed a final position on that, and that would be in my right of reply. Matt, do you have any further comments on that from a transport engineering perspective?
Yeah, thanks, Melissa. I think I think you've covered it off well there, Ms. Pearson, but another aspect is that healthcare facilities do have a degree of control over the number of trips they generate, and that's through how they roster their staff, how alternative transport modes that they might provide for their staff, things around where their car parking is accessed, etc. So yeah, I agree with everything Ms. Pearson's just said, but I'll also add that healthcare facilities do have some ability to control the number of traffic movements they generate.
I think that answers the question pretty well, but what if somebody put it to you that was a narrow view that you were both putting forward, particularly hearing from a transportation engineer in that respect. I mean, wouldn't a planning response take account of the wider issue about where hospitals are better to spend their money rather than on car parking? They'd be better spending their money on providing health services.
I mean, one of the recommendations, well, one of the consequences of recommending a removal of minimum parking rates, it actually addresses one of Te Whatu Ora's submission concerns, which was that the parking minimums were too restrictive for hospital services and they wanted to be exempt from them or have different rates. So they do have, I guess, more flexibility now to provide car parking spaces as they see fit. Agree that consideration of the balance of where money could be better spent for hospitals is something that I could consider, but as I say, I haven't come to a final firm conclusion as to whether or not hospitals should be exempt. I do note that in the evidence, and I'd be interested to hear what Te Whatu Ora present tomorrow, is that they do talk about exemptions for the hospital zone, but then in other points they talk about hospitals and healthcare services, and I do see those two things as potentially a little bit different. So yeah, I'd be interested to more fully understand the scope of what they would like exempt, whether they're just seeking an exemption for the hospital zone, which only affects 3 sites in the far north, or whether they are seeking a broader exemption for healthcare services, regardless of where they're located.
Thanks. Yeah, I guess we'll hear from Ms Hamilton in due course. Thanks. Any questions?
Multiple, but I think I need to hear.
Yes, I've just got one other question on paragraph 446, the 447, which is garden fire fence. It seems to refer in the first 446A to the minimum carriageway width of being 3 metres for rural areas and 2 to 4 metres for residential areas. And fens are talking about the width of the fire engine. Do you know? Does anybody know what width a fire engine is? I mean, 2 metres for a rural urban area seems awfully narrow for a carriageway.
I'm going to pass that question to Mr. Collins, because you happen to be fortunate in that you have a transport engineer who also has been involved professionally with the firefighting service as well in a past life. So he's quite familiar with the requirements related to fire engine appliances.
Yeah, so the legal width of a heavy vehicle, maximum legal width is 2.55 meters. I'm pretty sure it might be 2.5, it might be 2.55 meters. That's the maximum legal road width of any heavy vehicle.
Okay, thank you. Thank you very much. No further questions? No, we've got no further questions. Thank you, Mr. Bates. Thank you. Thank you very much. Right, well, is that all the officers?
Thank you, Mr. Chair. I believe so.
All right. So I think now we've Forest and Bird, Mr. Williams and Mr. Bayesian Mercer, is it?
Good morning, Commissioners. I'm not sure if
it's circulated. We can hear you and see you.
Thank you. I'm not sure if Dean is with us today, actually, Mr. Bayesian Mercer. I think it might be just myself.
Okay, I thought I saw him earlier on, but I'm possibly not.
Well, thank you for the opportunity to present today. It's appreciated. I hope you've had a chance to have a look at the written submissions that I sent in. They're addressing the infrastructure and the REG chapters. I don't have any comments in the submission on the transport or designations chapters. And so I'd just like to take you through those submissions if I can, and then answer any questions you may have. So perhaps beginning with, there's a point which arises in relation to both the REG chapter, REG objective 3 and also the infrastructure chapter, infrastructure objective 4. So if I could perhaps just begin by addressing the concerns that we have about the changes that have been made to those objectives. And the same points really arise in relation to both of those objectives, which do quite similar things in the context of the plan. I understand that those changes were made following pre-hearing meetings with various submitters, and I'd just like to acknowledge that we were invited to attend those meetings, but unfortunately we didn't have capacity. So it would have been good to have been able to raise our concerns during those meetings. Unfortunately, that wasn't possible. So that's need to do that today. I just want to acknowledge that we were invited to participate. I think it was Jerome earlier indicated that he thought that the submissions which I've made here, our concerns are based on a misunderstanding. So it may be that well, hopefully this will be a helpful exercise in order to see whether that's the case or not. If I could start with just a sort of high level point, which is to do with the way that plans are structured. And my understanding is that the objectives, and this is, I just sort of refer you to my submissions actually as I go, it may be helpful. This is a point that I've made at paragraph 4. So in general terms, that objectives should state what's intended to be achieved, and then the details of how that's to be achieved should be set out in the policies. So it's quite unusual, I'd suggest, to have details of an effects management approach set out in the objectives. Normally you'd see, high level objectives around what's intended to be achieved. So, here in the REG chapter, for example, you have, objective 1, which recognizes the significant benefits from REG activities, and a couple of other objectives similarly. That's a standard approach, but then when it comes to how you actually manage the effects of an activity, how you do that, that would normally be set out in the policies. And you can also see that, for example, in the ecosystems and indigenous biodiversity chapter, where you have high level objectives, but then the actual effects management approach is set out in the policies. And our concern is that by providing for what seems to be a limited approach to effects management in the objectives, you are effectively creating a kind of a carve out for these activities when it comes to deciding how to manage the adverse effects. So, rather than having the general objective, which should be to manage adverse effects appropriately, you're directing decision makers to take a limited approach to how to manage effects, and to manage them simply in a way that recognizes and provides for the operational and functional need of renewable electricity generation activities to be in particular environments. So that's, in a nutshell, I think the concern is that that will then limit the way in which the adverse effects of these activities are managed. And we suggest that that's not an appropriate way of doing it, because, of course, the effects management approach needs to be much more complete. It needs to give effect to Section 5 of the Act, and various other considerations as well. It's not just about recognizing and providing for the needs of renewable electricity to locate in particular environments. So yeah, in my submission, it would be better to put that into a policy, which can then be considered alongside the other policies that may be relevant in terms of managing effects. And you can see that has already been done in the INF chapter, for example, where you already do have INF policy 5, which requires the council to manage adverse effects in a way that recognises the operational and functional need of regionally significant infrastructure to be located within certain areas. So that approach, which we say is the correct approach, has already been adopted, at least in relation to the infrastructure chapter, and it's goes not appropriate to go further and actually use an objective to potentially create a sort of a carve out in terms of how you manage adverse effects for specific activities. So
Well, I've got some questions of you.
There might be useful to ask a question now, Tim, rather than before you go on with your submission. One of the difficulties in reading what you put in your legal submissions there is, I follow the argument fine, and I can understand that certainly in terms of consistency of the plan, but you use that word appropriate and suggest that the word appropriate should be used there. Let's have a problem with that. I mean, isn't that too subjective a term to be used in any provision in the district plan?
I have seen it elsewhere. I appreciate that it's very general. The problem is, I think, really around just making sure that your objective in terms of managing adverse effects is appropriate in that it doesn't limit the way, and as I've said, the way in which those effects are considered, or the way in which you manage those effects. So I've used that word just because it's sort of a bit all-encompassing. An alternative would be to also refer to avoiding, remedying, mitigating adverse effects, and sort of include that in the objective in order to create a balance.
Yeah, so you drop the word appropriate and talk about managing adverse effects in a manner that avoids, remedies, mitigates, which would be fine at duty level.
Yes, and that was the approach that was taken in the notified version. So that was the wording in the notified version, was designing activities, locating and designing activities to avoid and minimize adverse effects. So that wording could be included alongside the wording that's being recommended in the Section 42A report in order to achieve a balance, and to ensure that that is also being done, as well as recognizing and providing for the functional needs of infrastructure. But so that would be an option. I think my concern would still be a sort of one about sort of the generally the best way of structuring plans, which is that the objectives should just set out what you're intending to achieve, and then how you do that, including avoiding, remedying, mitigating adverse effects and so on, should really be in the policies, should sit under the objectives in the policies. So that's why I suggested the very general wording. So if there's going to be an objective relating to the management of adverse effects, then I've suggested that should be presented in very general terms, to ensure that the how of that isn't constrained. When you come to look at the policies about how you should do that, you're not being constrained by the objective.
Yeah, I guess the different view that people might have in that is that it's fine to talk about avoiding, remedying and mitigating in your objectives as such. When you get to your policies as to how you can actually implement that objective, you might not be avoiding, remedying and mitigating effects, you might be minimising them. So,
yes. Yeah, and there will be a lot of detail in the policies potentially around effects management, and So that's, I think, that's why I suggested the word appropriately. But I mean, the concern is, again, that you're not limiting what you can do, and the other policies that you can use. You might look at this objective and say, well, okay, this is our objective in terms of managing effects for REG or infrastructure. And then you look at the policies that sit under it in the REG and INF chapters, and that sort of creates essentially a complete suite of provisions that you need to look at. And you can say, well, we don't need to refer back to the ecosystems and indigenous biodiversity chapter, because our objective here for these specific activities doesn't require us to do that.
Yeah,
You don't need to manage effects in
objective thing gets too much into enabling things rather than that seem to be downgrading the effects at that stage, and they're more into enabling the infrastructure.
Yes.
And that's fine, thanks. Thanks.
Right. Anything else you wish to read? Anything else?
So there were a couple of more discrete points on some other policies which I would like to raise if I can. On REG P2, we have some concerns around the use of the word enable in the policy, which has been recommended in the Section 42A report. And essentially, I think that's hopefully quite a simple point, which is just that when we use the term enable in policies, it refers to generally permitted activity rules. So that policy will then provide the support for permitted activity rules. And the expectation is that where an activity is enabled by a policy, that it will be permitted. So my concern there is that actually this policy sits above a number of rules, which, although they do have a permitted activity status attached or included within them, where the conditions for the permitted activity aren't met, it moves to restricted discretionary or discretionary status. So my concern is that when a consent authority comes to look at an application which is a restricted discretionary or discretionary activity, they're referred back to the policy which tells them to enable the activity, which would imply that consent can't be declined. Whereas, of course, for restricted discretionary or discretionary activities, it's, the expectation is that if appropriate, the activity or the application rather can be declined. So that creates a tension there, which I've suggested could be resolved simply by shifting back to the wording that was in the notified plan to provide for. So that's that point on REGP2. I've said that we support the general approach, REGP5, of moving those effects management policies into the, or keeping those effects management policies in the, that relate to Indigenous biodiversity in the IEB chapter. I've made a point about our REG R3, where I think some wording was removed in response to our submissions, which were that if you included Indigenous vegetation removal as a matter of discretion, I think in the in REG Rule 3, that could imply that activity is also being managed under that rule, whereas the intention is that you should look back to the the IEB chapter. So I think that wording was removed in order to make it clear that those activities, vegetation clearance, are being managed elsewhere. I think here my concern is that that change that's been made doesn't go far enough, because there are other matters of discretion which would also need to be managed under the IEB chapter, the eco chapter, whatever we want to call it. So it would be better in my submission to actually link to or refer to the IEB chapter in the rules to make it clear for the plan users that when they are conducting activities which involve, for example, vegetation clearance or perhaps other things that are managed under the IEB chapter, such as effects on threatened or at-risk species, they do need to refer to that chapter. So that would just be a make it really easy for plan users in my submission. Make it clear that that is the intention of the plan. Then under infrastructure, there's an issue here which comes under infrastructure policy 2, which is that what I've called special treatment for infrastructure has been extended to all infrastructure activities according to the definition of infrastructure in the Resource Management Act. But the definition of infrastructure in the Resource Management Act is very broad, and I've pointed out that it includes, for example, irrigation. This is at paragraph 41 of my my written submissions. The definition of infrastructure in the RMA includes, for example, irrigation systems, drainage or sewerage systems, systems for transport on land, or for loading or unloading cargo or passengers by any means. And those activities are included regardless of whether they're municipal activities or whether they have any public benefit. They could just be activities that are being pursued by private landowners for their own interests, their own private interests with no public benefit at all. And if you extend the special treatment for specified infrastructure or regionally significant infrastructure to all infrastructure, then you're limiting the ability of the consenting authority to manage the effects of those activities in a way that would be appropriate. So and yeah, those are the key points that I wanted to raise. Thank you for your time. Happy to answer any questions.
If we've got any further questions.
This one, but you've read the 42A report.
I've read the 42A report. Yes, I did. For the REG and INF chapters, at least.
You've got no further questions, so I mean, what will happen? Obviously, the officers will do their right to reply. I think you were here when I did the opening, didn't you? Online when I did the opening.
I'm sorry. I didn't quite catch that.
Well, you were online when I did the introduction to the hearing.
Yes.
Aware what will happen now? You're aware what will happen now?
Yes. Thank you.
They'll do the right reply. They'll take on board what you've said and they'll reply to us. Obviously, we may not agree with the officers. We may disagree, but then we will be able to read your evidence again when we do our deliberation. Thank you for the evidence.
Thank you.
Thank you very much. Thank you. Now, I think
So next up is the lunch break, which we've got scheduled for 12:30. These gentlemen will be speaking after lunch.
it's time now.
It is 12 o'clock. I can go and see if they can.
How long are the accountant going to take?
We could roll early.
Pardon?
We could go early if it's more convenient for you.
How long are you going to take? Half an hour?
No. At the hopefully not. This garrison's going to have 60 pages. Yeah. We're going to make it.
Beautiful seats. That's going to
We take those as you read.
I'll make contact.
Come on in, come forward, gentlemen. We've got Mr. Horn, Mr. Harrison, and Mr. Campbell.
Yep, that's correct.
No, no. Well, my colleague just said to me that if you need to continue on after lunch, we can do that, rather than cut you off. So, we've got the evidence, we've got evidence of Chris Horn's, a joint statement from.
So I'm Graham Carrison, It's obviously have Andrew and Chris with us. So where we got to, given the work that we've done pre-hearing with Jerome and the other infrastructure providers, we've basically got down to a few points which Chris will outline. We did notice that in North Power's evidence there was a interesting statement around or request for change around phone booths. So happy to answer a question or explain that if that assists the commissioners after Chris has gone through his statement.
Yeah, just to help on that, I'm Chris Horn, by the way. Good morning. The telcos don't have any submission standing on the telecommunication kiosk, but that rule is normally intended for phone booths. And I saw that David Badham's evidence was talking about mounting them on poles. So I wonder if that's just a misunderstanding of what that rule's all about. And maybe that's a question for him in due course from yourselves. I might as well kick into it then. So I haven't had the opportunity to hear if Jerome had any feedback on my evidence because we were travelling this morning. Have I missed anything I should be aware of?
I haven't provided anything we normally address.
Normally, what happens is we hear the evidence, we'll have our break, and once we finished all the evidence, they may come back and give some verbal comments, but then they go away and do the right of reply, and we normally get that about 2 or 3 weeks, is it? Normally, yeah. Something like that, and that gets circulated to you.
Okay.
But they may also give us verbal comments beforehand as well, but it'll be once we've heard all the evidence today.
Thank you. So I've got I did circulate just a 1.5 page summary. I guess in a nutshell, there's only one point of difference with the 42A report from my point of view, which is mainly around tidying up some cross-referencing and actually offering more restriction on one of the rules. So I'm hoping that's not too contentious. But if I just quickly whip through the summary, so Mr. Weiss suggesting deleting policy P3 and modifying P2. And just recording that I support that recommendation that P3 was overlapping with overlay policies and they'll still apply in any case. So just confirming that I support that particular amendment he's recommending. On the rules, rule R5 is to do with new above ground customer connections, and the plan is notified only allowed those in very limited zones, and that doesn't reflect that in many cases the network's already above ground and that would be the typical means of connecting. So Mr. Waits recommended that be provided for in all zones, but that there's restrictions on adding poles in settlement residential zones, which are the more sensitive zones. I support that recommendation. And then probably the key one for the telcos is when the plan was notified. So in the current operative plan, you can build 20-metre high poles and attached antennas in all zones except Russell. And in the notified plan, you basically couldn't build them anywhere but about 3 rural zones. So that was a fairly inconsistent approach with most plans that we deal with. So that was in the pre-hearing process, we had quite a bit of discussion around that and provide quite a few examples. And so Mr. Waith has come back with some varying height limits for different zones, with the heights being different depending on the sensitivity. So that's consistent with what the telcos were looking for through the pre-hearing process, and I support what's been recommended there. I just note that the rule covers poles and antennas and overhead lines and poles, and I've never seen those combined in the same rule before. It's quite unusual. And I know Mr. Badham for Top Energy seeking different changes in regards to lines network. So I just wonder if they're better split into two rules in case they diverge over time in terms of what the panel's view may be on the heights or what other submitters might be looking for. So it'd be useful to see the council's right of reply on that point. But from the point of view of poles and antennas, it's absolutely fine. It's some of those heights are way more than Mr. Cantor would need for chorus. I think they have standard sort of 9 and 11 metre high poles, so it's probably more a Top Energy issue. And I also recommended that a height to boundary apply to poles and antennas at residential site interfaces. And in the road corridor, not a height to boundary, but a 1 metre diameter restriction, which essentially limits you to those sort of light pole scale type facilities with tight clusters at the head. That's the really the guts of it on the infrastructure section. Also, there's the designations report, and I must apologise if the officers here, I don't know. You're Lynette. Hello, Lynette. So Chorus and Spark, and the current plan shows them as telecom designations. Those companies demerged. It's all in the report. A bunch of them went to Chorus. Some of them got granted back to Spark as secondaries. One of Spark's that they retained, they're not rolling over. And there's no modifications, in my opinion. So the wording changes slightly to the purpose, but that's just for national consistency. It doesn't actually change what it enables. So in my view, that's not a modification. And Spark had just lodged one submission to tidy up the correct requiring authority name, which is Spark New Zealand Trading Limited rather than Spark NZ Limited. So subject to that change, fully support the recommendation from the officers to confirm those rollovers. And that's everything I've got, Stern.
Question? Yeah, the idea of a separate category of activity, the differential 0.6 that you raised in your evidence earlier. Is David Badham got a concern with that at all in terms of what he put forward in his evidence?
So he's happy with the heights, except he wants towers that are limited to 15 metres high in rural zones. So towers are distinct from poles. The way the plan works, poles are monopole, towers are lattice thing.
Yes.
He's wanting more height for that, for Top Energy, and the telcos don't have an issue with it the way it is. So I guess the suggestion to split them is if standards do diverge for different sorts of networks, it would be a shame for the telco stuff to get tied up with line stuff if it's not an issue.
The other questions for Mr. McGarrison, he'd be disappointed if you came to him and have a question for you. I think I must be doing my job.
Absolutely.
Just, I know you've been sort of making submissions or evidence on a sort of a regional basis around North. And how are you advancing with that? Because you gave us a very comprehensive statement about how things were going. I mean, one of the things we've heard during the course of the hearing is been put to us the need to line up with what Whangarei District and Amsterdam are doing. I guess Hyper, and most of us, and they'll probably follow on more than anything else. Can we make progress? Yeah.
Can I make one point on that? Whangarei is a bit of a disaster. they've always been a zone by, yeah, they've always been a zone by zone plan. And so back in the day, they had zone by zone rules, including specific rules for antennas. And so it wasn't a utility section. And then they've done a bunch of rolling plan reviews over time, and somehow it's been missed, but all those antenna specific rules have dropped out of all the zones, but they haven't been pulled into the utilities section, which is more a policy chapter with some provisions mainly around transmission lines. And it actually leaves a whopping great hole in that plan. So I think the far north, I prefer they followed far north than the other way around.
Yeah,
No, well, that's true. Good point. And Kuipera's notifying today, I understand, so they're a bit behind that ball, don't know what's in there yet.
Yeah,
You got a sense that, to us, that, if we do anything in terms of a plan review, that it's a matter of rationalising the infrastructure providers, because they seem to struggle for years to come across.
I mean, it's been great in like Wairarapa and West Coast where they've gone for a combined plan and they've all got the same provisions, which look more like these Section 42A provisions than the Whangarei example.
Yeah. And I suppose for us, we've been working nationally on getting an amendment to the National Environmental Standard for Telecommunications for 3-4 years now. And so the standards that we've been asking for in district plans have principally been aligning with what we're expecting to see in that, and have worked with government for both governments under the previous new legislation, the National Planning Framework. And then what is proposed, we're still got our fingers crossed, see it in a couple of months for the new National Environmental Standard, which may increase just slightly some of the heights here, but pretty consistent. So from our point of view, you know, this plan's been a long time coming, and so there's been a few iterations, but we think, thanks to the work done at the hearing stage, that we're in good shape, basically.
Just can't get it clear, Jerome. They wouldn't be permitted in Russell Township, would they? This height?
15 metres permitted in Russell. So that's more the lower limit, more sensitive zone.
All I'm thinking of is, I mean, I don't know when you go out and pick the sites, but if I look at that, I'm sure you probably still get the coverage and move it somewhere, so it's not taking that way going forward, so they use the expression. And I just wondered, do you have when you go out to look at the site, I know we have a technical reason why, but do you have anybody who goes out to landscape architect or planner or something and says, well, let's move it 10 metres that way and stick out and put it together for that building, so it's got buildings again, you know, a tree next to it. I mean,
so what typically happens is there's a bit of a it's called a caravan because people don't know it's carpool, but you've generally got a radio engineer, a civil engineer, a project manager, a planner, and a property consultant tend to go out and look at multiple candidates, and everyone puts their 5 cents worth in, and certainly planners are on site making those kind of suggestions. And then the project manager and the company ultimately make the decision which one they want to go for. But certainly all that input's taken into account. The other thing is that's a very tight little photo. If you look at it on a more expansive level, you'll probably find it doesn't look.
You provided the photo.
I did, because I wanted you to see it. And it was a local example. That was it, yeah. So, and the other thing is I would imagine some of Russell is probably heritage precinct. And if it is, that would tag out any heritage precinct rules would tag out general zone rules. So that probably wouldn't be permitted on that basis.
Yeah.
I'm just thinking because Russell Township gets mentioned a lot.
Yeah.
Okay, thank you.
And it was the one zone in the legacy plan that it wasn't allowed in as of right.
Yeah, just reference under the footy road report transport clause or paragraph 159, top energy wanted appropriate provision made for infrastructure and transport, particularly electricity and telecommunications. Do you have any comment on that?
No.
Do you need it?
So telecommunications has, its national environmental standard allows a lot of its lines network work anyway. Actually, Mr. Cantor's more across that than me, but so a lot,
Yeah.
so a lot of that stuff's enabled anyway. So I hadn't particularly considered the transport clause because the utilities rules will be the ones that enable it anyway, not the transport section. I'm not quite sure what he's asked of me.
Just clarification, if you go to in the road corridor, 1 metre diameter, is that to build the tower? What's
Yes.
the offset from the boundary?
No, that's the diameter of the structure. So that would be the antenna cluster in the shroud at the top.
That's within the road corridor?
Yes, that's within road corridor, correct.
Yeah.
And just on your previous point, our national environmental standard essentially directs us to locate our infrastructure within the road reserve, because as long as we're within the road reserve, we're permitted. Once we go beyond the road reserve, it's sort of subject
Go and
to.
check it as well.
It's,
Mr. Lewis, is there any comment you want to make at this stage? Because these gentlemen here and Mr. Batten and things are fairly close. I mean, you may not want to.
No, just to reiterate that, I think we're in a good place and the pre-hearing discussions really assisted with that, and I'll provide a lot of examples and evidence to support some of those height limits. I think the additional control suggested around introducing types of boundary standards and residential zones, I'm supportive of that. If that works for the telco providers, I don't have a strong view about whether we separate out the rules relating to overhead lines or communication poles, but we can probably discuss that further in Top Energy tomorrow. But in general, I'm pretty happy with where we've got to.
Just wondering, just as a final clarification to the chair, do you have a strong preference between the operative provisions or the provisions of Mr. Blythe's section 32A?
Is that how you say it, Wyatt? My bad. The 42A.
Thank you.
So the other one's a straight 20 and it doesn't really, sometimes 20 is probably too much. Sometimes it might not be enough.
You see what I'm very grateful for lunch now, really.
Yes,
We're going to follow these gentlemen.
yes, they are not.
Oh,
Excellent.
it's there.
Plenty of.
Love to stay, thank you. Yeah.
You can put your shoes on when you go through it.
Yeah. I will stop the recording.